The two appellations, forensic and expert, are not clearly distinguished in the literature with respect to the role of social anthropology in legal proceedings. Social anthropologists called upon to submit evidence in legal matters are most often termed expert witnesses and more recently cultural experts. However, the appellation forensic has appeared in relation to social anthropology in the USA, Latin America, and in Australia. It is proposed here that both forensic social anthropology and expert social anthropology constitute interlinked forms of cultural expertise, comprised of specific probative functions and relations across a range of legal processes and jurisdictions. This paper describes a formal model by which courts, tribunals, and other legally empowered bodies may distinguish between two roles that social anthropologists perform in using their cultural expertise. The objective of this exercise is to clarify the distinction between cultural expertise at a general level and the two roles by which this expertise is delivered, either in terms of forensic investigation or expert witnessing. The paper summarizes the origin and contemporary roles of social anthropologists in legal proceedings, then frames the distinction between forensic and expert social anthropology in terms of the legal distinction between fact witnesses and expert witnesses. This framing is contextualized by the scope for consilience between social anthropology and both its sister field of physical anthropology and the law, which are both presented as complementary vehicles for advancing anthropology's broadly held ethical commitments. The advantage of this emerging consilience for both the field of social anthropology and the intended beneficiaries of its ethical commitments is conferral of higher probative weight upon the field of social anthropology by the law. Wilson, in 2016, identifies in various international proceedings a preference for natural science rather than social scientific evidence. Corroborating this observation, Campbell, in 2020, argues that this is not a preference that will be neutralized by social anthropologists' persistent claim to equivalence or even higher moral or intellectual authority than the judicial branch of government, an endeavor that is now 40 years old. Rather, it will be by demonstration of the field's formal and empirical maturity, its technical sophistication, and its readiness to conciliate as one of two fields within the common discipline of anthropology. By working towards a formalized model of the roles, functions, and relations that integrate social anthropology into legal proceedings, we therefore enhance both the probative and ethical potential of the field. Anthropology may be construed as the parent discipline of two child fields, physical or biological anthropology, and social or cultural anthropology. The distinction in nomenclature in both cases is an expression of the relationship between distinct causal models within each child field and the domains of observable variation that they purport to measure. The parent discipline of anthropology measures variations between human communities distributed over geographic space and historical time without reference to a single unified model of causality. Within the parent discipline, the child field of physical anthropology measures variation in human physicality across the same spatio-temporal axis and uses causal models of biological processes as an explanatory framework for making predictions about that variation. An example is the predictable prevalence of certain hereditary traits within communities that exist or previously existed in one or another particular region of space-time, where causal models include those of osteology and genetics, for example. The other child field is social anthropology, which measures variation in human sociality across the same spatio-temporal axis and uses causal models of cultural processes as an explanatory framework for making predictions about that variation. An example is the prevalence of certain modes of organizing social relationships within communities that exist or previously existed in one or another particular region of space-time, and where causal models include religious and economic themes of thought, for example, and their dependent modes of instantiation in social behaviour. Each of these two child fields of the parent discipline of anthropology may be referred to by either the object of measurement, i.e. physical variation or social variation respectively, or by the respective corollary causal model, i.e. biological processes or cultural processes respectively. This has given rise to a situation in which British and European scholars tend to refer to physical anthropology and social anthropology respectively, whereas US scholars tend to refer to biological anthropology and cultural anthropology respectively. Both child fields of the parent discipline of anthropology have developed various specializations over time, including, for example, osteological and genetic specializations within the field of physical anthropology, and religious and economic specializations within the field of social anthropology. A noteworthy difference in the criteria for specializing between the two child fields of anthropology is that the specialization in physical anthropology tends to be functionally oriented, whereas specialization in social anthropology tends to be thematically oriented. To extend the examples above, osteological and genetic anthropology specialize in skeletal and genetic functions as subsets of broader biological processes. By contrast, religious and economic anthropology specialize in religious and economic themes of thought, classifying them as systems of ideas which are subsets of broader cultural processes. Similarly, regionalized specializations of social anthropology that focus on particular communities of people tend to do so by classifying specific themes of thought according to their delimitation in space-time. This gives rise to multifarious community of origin specializations within the field of social anthropology, such as Australian anthropology, Amazonian anthropology, African anthropology, and so on. An exception to the distinction in criteria for specialization within either of the two child fields of anthropology is the specialization of forensics. In this case, both physical anthropology and social anthropology specialize on the basis of the same criteria, which is the admissibility of evidence to legal proceedings overseen by a court or other legally empowered body. In this case, both physical anthropology and social anthropologists are called upon either individually or in combination to collect data regarding the physical or social variation of a person or community of people, however so defined, to deploy demonstrated and testable modeling and analysis techniques useful in measuring those variations, to derive an opinion from the results of that modeling and analysis, and/or to present the modeling and analysis results and the derivative opinion to the presiding legal authority. Thus, in the case of both forensic and physical anthropology, both forensic physical anthropology and forensic social anthropology, the criteria set by the court or other legally empowered body is one of relevant specialized knowledge based on a person's training, study, or experience, as it is phrased by the Australian Commonwealth's Evidence Act of 1995, where that specialized knowledge can usefully demonstrate the existence of certain facts and then provide a useful explanatory opinion as to how those facts arose based on a line of reasoning that links facts to opinion according to the accepted causal models within the relevant field of expertise. We may refer to this as a three-part, three-phase model of forensic physical and social anthropology, as illustrated here. The three parts comprise A, an object of study, B, parameters of study, and C, model of causality. The three phases map the transition from 1, scientific paradigm to discipline, 2, discipline to field, and 3, field to forensic specialization. Despite the convergent criteria for forensic specialization in both physical anthropology and social anthropology, the differential maturity of the two fields has resulted in differential engagements with the areas of law in which they are deployed. This differential maturity may be measured in the level of the two fields' respective formalization and professional regulation, the level of consistency in the terms and definitions that constitute their technical languages, and in the sophistication of the technology that they each employ in measuring variations among human communities, along with the modeling of causes for that variation. Physical anthropology has matured together with its corollary disciplines of biology and medicine, especially due to the advances of biochemistry, genetics, and powerful digital modeling and analysis technologies. By contrast, with the exception of kinship analysis, social anthropology, as an integrated field of expertise, has not definitively matured according to any of these measures since the 1970s. The consequential differentiation in engagement of physical anthropology and social anthropology with the law is evident in the expectations of presiding authorities, including judges, solicitors, tribunal delegates, and others. A canonical example of these expectations, at least for Australian forensic and expert social anthropologists, is provided by Australian Federal Court Judge Justice Blackburn in his decision in Millerpool and others versus Nabalco Proprietary Limited in 1971, a claim brought by Indigenous Yolngu people against the mining company Nabalco for mining in a traditional territory in the Arnhem Land region of far northern Australia in the 1960s. Social anthropological evidence played an important role in the claim. Legal representatives for the Nabalco mining company attempted to have the expert social anthropological evidence dismissed on the grounds that it was hearsay rather than expert evidence, because it was based on consultations with Yolngu people about their culturally based title claims to the mine site. In his reasoning, Justice Blackburn stated, quote, "My ruling is based on accepting that there is a valid field of study and knowledge called social anthropology, which deals with the social organization of primitive peoples. The process of investigation in the field of social anthropology manifestly includes communicating with human beings and considering what they say. The social anthropologist should be able to give his opinion based on his investigation by processes normal to his field of study, just as any other expert does. To rule out any conclusion based to any extent upon hearsay, the statements of other persons, would be to make a distinction for the purposes of the law of evidence between a field of knowledge not involving the behavior of human beings, say chemistry, and a field of knowledge directly concerned with the behavior of human beings, such as social anthropology. A chemist can give an account of the behavior of inanimate substances in reaction, but a social anthropologist must limit his evidence to that based upon what he has seen the Aboriginals doing and not upon what they have said to him," end quote. Justice Blackburn's reasoning brings into high relief the distinction between, quote, "a field of knowledge not involving the behavior of human beings and a field of knowledge directly concerned with the behavior of human beings." This reasoning maps clearly onto the distinction between physical and social anthropology, but at the same time illustrates precisely why the probative standard expected of both fields is the same from a legal perspective. Justice Blackburn goes on, quote, "I do not believe that the law of evidence requires me to put chemistry into one category and social anthropology into another. The matter can be tested, it seems to me, by applying the analogy of medical evidence, with which courts are so familiar. This is a field in which the facts include both what the expert observes and what he hears from other persons, his patients. A medical expert gives evidence in this form. I have studied the subject of coronary heart disease. The study includes observing the anatomical and physiological facts, talking to patients and considering what they say, studying the literature, etc. I express the opinion as an expert that proposition X is true of coronary heart disease. There is no doubt a considerable difference in degree between the extent to which statements made by other persons form the basis of conclusions in clinical medicine and in social anthropology, but in my opinion, it is not a difference in kind, end quote. Proposition X, as Justice Blackburn puts it, is the critical issue for the admissibility of social anthropological evidence in legal proceedings. This is because the causal logic that links facts to opinion is the primary probative factor for any given field of expertise that courts or other legally empowered bodies may recognize. Expert evidence that provides no compelling connection between facts and opinion is broadly unhelpful to the law, no matter the field of expertise and no matter which party seeks that expertise to advance its case, whether claimants or respondents. It is therefore imperative that social anthropological evidence proposed for submission in any legal proceedings commence from the basis of a clear distinction between demonstrable instances of social interaction and a causal model that links those instances of social interaction to culturally specific systems of ideas that can be shown to have given rise to those instances of social interaction in the first place. The criteria for defining forensic specialization in either physical or social anthropology involves a further clarification of the term expertise and its meaning in legal settings. Holden in 2019 traces the development of social anthropology's current relationship with the law as one of expert witnessing, developing from colonial administrative expertise in the service of British and European empire during the 19th and early 20th centuries, through to social welfare and counterinsurgency expertise in the service of both foreign and domestic policy development after World War II. The normalization of social anthropological expert witnessing in legal proceedings during this latter period occurred against a backdrop of liberalization in social anthropology's de facto home in the academic humanities, so that social anthropological advocacy of social justice causes became deeply ingrained in the teaching of the field, independently of the concept of research ethics and integrity, which developed more thoroughly in medicine and in the sciences. This divergent trajectory culminated at the beginning of the 21st century with a situation in which social anthropological expert witnessing has become routinely mired in allegations of evidence fabrication and complaints of bias from legal professionals. Simultaneously, the field's ethical foundations remain unevenly distributed and ineffective, as illustrated by the US military's attempted weaponization of social anthropological expertise via the so-called human terrain system in its 20-year invasion of Afghanistan between 2001 and 2021. Holden's proposed solution to this checkered history of expert witnessing is to set out the terms and definitions of an ethical rather than advocatory practice, rooted in an acknowledgement that expertise is most useful to achieving just outcomes when it is based on a dispassionate and properly formalized understanding of its relationship to the law. Cultural expertise, rather than expert witnessing, describes that range of social anthropological knowledge and practice that, quote, enables socio-legal scholars, experts in non-European laws and cultures, or more generally speaking, cultural mediators, the so-called cultural brokers, to locate and describe relevant facts in light of the particular background of the claimants and litigants and for the use of the court. Holden in 2019 goes on, quote, not differently from any other form of expertise in court, the purpose of cultural expertise is to apply special knowledge to a definite set of circumstances submitted to the expert, whose considerations must be elaborated irrespectively from the legal outcome of the case. There are three elements in this summary that intersect with the three-part model of forensic specialization outlined earlier. 1, purposeful specialized knowledge. 2, a definite set of circumstances submitted to the court, to the expert, by the court. And 3, elaborated consideration of those circumstances using that specialized knowledge. Firstly, purposeful specialized knowledge is that which, as outlined earlier, furnishes a self-consistent set of terms and definitions for identifying a relevant object of study, spatiotemporal parameters, and a model of causality. Secondly, a definite set of circumstances is that specific instance of the study object delimited by a specific region of space-time, i.e., the scope of the matter before the court. Thirdly and finally, elaborated consideration comprises the application of a field's specialized causal model to that subset object of study in order to explain the causal links between facts that have been identified as relevant to the matter. Holden's definition of cultural expertise is also consistent with Justice Blackburn's 1971 reasoning in Millerupum v. Nabalco. Justice Blackburn is clear that as far as the Federal Court of Australia should be concerned, social anthropology's specialized knowledge is derived from both observation of a community's social behavior and interviews with community members about that social behavior. The definite set of circumstances are those that are of interest to the court, i.e., the particular social behavior and particular community subject of the matter before the court. Finally, the elaborated set of circumstances are those that allow the expert to put forward Justice Blackburn's Proposition X by triangulating the causal relationship between observation and interview responses. How does the concept of cultural expertise interdigitate with the model of forensic social anthropology and expert witnessing? In his 1971 decision, Justice Blackburn sets out the two types of information that an expert is expected to provide to the court. A, observable facts subject to the legal process, and B, a testable explanation of the causal relationships between those observable facts. Korn, in 1966, allocates these two types of information to two different expert functions. One, active investigation as a means to establish the facts of the matter, and two, responsive communication of technical information. This distinction gives rise to what is known as the dual role of experts in legal proceedings. Freckleton in 2019 explains, quote, "When an expert is engaged in the context of an existing litigation or a prospective litigation, he may perform a dual role. The first is advisory, and the second is in his capacity as expert witness, with all the responsibilities to the court as which that entails. In one sense, all communication by an expert to his client constitute advice in one shape or form. He may advise him of his factual findings following an investigation. He may advise him of his conclusions based on those findings and/or other established or assumed facts. He may suggest a particular strategy or tactic. Part or all of this may be included in a report to be lodged as a production to which he may in due course speak. All of the foregoing may be intimately or closely connected with proceedings, actual, contemplated, or possible." Forensic physical anthropologists are familiar with these dual roles, generally categorized as those of fact witness and expert witness. However, there is little discussion of this distinction in the relevant social anthropological literature. The two sets of expert function that Freckleton in 2019 and Korn in 1966 describe may be elaborated into more specific and coherent functions within the court generally, and the roles to which those functions are attached, by reference to concepts of judicial governance. In describing the distinction between forensic social anthropology and expert social anthropology, it is necessary to clarify that the engagement of social anthropology with the law is fundamentally a matter of what is called judicial governance, according to Kapaszewski et al. In 2013. Judicial governance describes a process whereby, through the accumulation of either common law precedent or statute, judicial processes evolve administrative functions over time, which either directly or indirectly influence the broader governance of multi-level jurisdictions. Justice Blackburn's influential decision regarding the roles of social anthropological evidence and its position vis-à-vis the hearsay rule in Australian law is an example of judicial governance in action, introducing an equivalence between chemistry, medicine, and social anthropology that had not been previously considered under Australian law. As such innovation becomes gradually familiar, it takes on a more procedural quality, much like that of any other form of governance. All governmental systems, including judicial governmental systems, operate through the agreed definition of three intersecting elements, known as roles, functions, and relations, according to Calibra et al. In 2018. This would be intuitively comprehensible to most social anthropologists who have engaged with legal systems, where they understand that their role as either or both forensic investigator and/or expert witness has been conferred with a specific set of functions, and that their role and associated functions interact with other roles and associated functions within the framework of the proceedings in which they are involved, such as those of judges, solicitors, tribunal delegates, and others. Accepting this frame of reference, we may summarize the roles and functions of social anthropologists within legal proceedings and their relations that link them to others within those proceedings as delimited by the range of functions that cultural expertise is called upon to serve. This is my last slide, so apologies for running a little bit over time. Taking into account this range of functions, the probative role of social anthropological expertise may be characterized as distributed along a continuum between the two functions identified by Freckleton in 2019, with investigation at one end of the continuum and expert witnessing at the other end. This corroborates the characterization made by Korn in 1966, who distinguishes between the functions of active investigation and responsive communication in similar terms. In elaborating a model of judicial governance in line with Kapaszewski et al. In 2013 and Calibra in 2019, the distinct functions of social anthropologists' dual roles in legal proceedings are accompanied by distinct types of relationship to other roles in the court. As Freckleton 2019 and Korn in 1966 note, the investigative role is associated with an advisory relation to legal proceedings, while the expert witness role is associated with a responsive relation, where the expert responds to specific questions put to them on the basis of previously established facts. This system of roles, functions, and relations is visualized here. As with forensic physical anthropology, the distinction between these two social anthropological roles are not mutually exclusive. An individual social anthropologist retained to provide evidence by one or multiple parties, or by the court itself, may perform one or a combination of roles on a case-by-case basis, according to the existing or evolving complexity of the matter over the course of its hearing. For this reason, the distinction should be construed as distributed across some region of a continuum, rather than at any single point. The substantive difference in the two potential roles of social anthropologists in legal proceedings as either forensic investigator or expert witness, to use Freckleton's and Korn's terms, is the degree to which the structure of the evidence itself has been directed by the relevant legal authority or by the social anthropologists themselves. The distinction between forensic and expert social anthropology is important for a number of reasons. Firstly, it clarifies the interaction of the field of social anthropology with the law according to the circumstances of the matter with which legally empowered bodies are dealing. This allows judges, lawyers, and other legally empowered authorities to make clearer distinctions about the intended purpose of seeking evidence from social anthropologists. If the circumstances are sufficiently well established, such that facts have already been agreed by participating parties, then a forensic investigation is less likely to be necessary, and specific questions of opinion can be put to the expert in order to obtain targeted responses. If, on the other hand, the facts have not been established, then responsive expertise alone will not be sufficient, and a forensic investigation may be necessary in order to assist in determining the facts. This assessment of need in turn determines the requisite areas of specialized knowledge based on training, study, or experience on the part of the expert, and may be used to inform the criteria for engaging either or both a forensic and/or expert social anthropologist. Secondly, the distinction between forensic and expert social anthropology allows us to return more pointedly to the question highlighted above of how to maximize the utility of a given social anthropologist in terms of the degree of their familiarity with a particular community of people. It is entirely possible that a social anthropologist with extensive experience researching with a given community may not have either sufficient technical expertise or sufficient formal training to provide evidence useful to specific legal proceedings. In such cases, forensic social anthropological investigations conducted by technically proficient and appropriately qualified practitioners, irrespective of their experience and familiarity with the subject community, may be more likely to render useful evidence than an expert witness alone. This assessment need not be a question of selecting one or another expert, but rather of assembling teams of social anthropologists with complementary skills and qualifications. This is a practice common in forensic physical anthropology, where multiple intersecting technical skills are necessary, such as osteology, genetics, odontology, and taphonomy, for example. In the case of social anthropology, such specific technical skills might include kinship, language, religion, and economic specializations, for example. The distinction between the two social anthropological roles of forensic investigator and expert witness proposed here hinges on the particular substance of what Holden in 2019 describes as, quote, the definite set of circumstances submitted to the expert. This is because the ability to assess a specific set of circumstances in a manner that involves the collection of useful data, the modeling and analysis of that data, and the detection of causal links between culturally specific systems of ideas and objectively measurable patterns of social behavior exhibited by that data requires both multiple technical skills and qualifications, a wide-ranging awareness of multiple dimensions of human social culture generally, and a pre-existing familiarity with the subject social culture in particular. We may thus consider forensic social anthropology and expert social anthropology as two branches of cultural expertise. Thank you.
Thank you, James. I would like to thank you, first of all, for engaging so deeply and productively with the concept of cultural expertise. I think that your talk addresses some of the questions that we have asked ourselves and our respondents during data collection in 16 European countries, also including the UK and Pakistan, India, Indonesia. Whereas you contribute with a theoretical approach that starts in Australia and resonates with US and the legal traditions, the academic classification. So I have the sense here that there is a potential for real innovation that makes sense interdisciplinary and across geographic macro areas, especially if we can further extend our reflection and include perhaps more academic traditions. I will come back on that very soon. What I think that the start of your paper it makes really sense in setting your analysis. You started your talk also by acknowledging the position of social and cultural anthropology vis-a-vis physical anthropology or biological anthropology, which are considered branches of anthropology in the UK and in the North American academic system. And so, very rightly, I think you say, and you share also what or many, at least, authors who have studied the role of anthropologists as expert witnesses have always lamented the fact that the evidence proposed by anthropologists is likely to be considered as having less weight in court than the evidence provided by physical anthropologists. This is partially due, and I agree with that, with the reputation of natural sciences over social sciences. But you also mentioned something that is very interesting, the methodological maturity, the sophistication of the discipline of physical anthropology, which is able to produce convincing evidence. And I'm wondering there if at the same time we could also make use to some extent of the criticism of the sociology of sciences, whose author probably would have something to say about the supposed authority of natural sciences. Nevertheless, I think that we cannot but agreeing with you on the fact that although according to the law, at least in theory, both physical and social anthropology can produce evidence, the weight which is usually recognized to the evidence of the first is disproportionately higher than the weight that is considered that is recognized to the evidence produced by the second. And then your talk has scrutinized the applicability of cultural expertise and identifies some components of the definition of cultural expertise that constitute both an advancement for previous positionality of social anthropologists and the potential for application across the disciplinary specialization. These are purposeful specialized knowledge and the finite set of circumstances submitted to the expert, and elaborated consideration of those circumstances using the specialized knowledge. I thank you very much for engaging with this component of the definition of cultural expertise, because if they make sense in a wider and from a wider perspective, somehow it is rewarding. I thank you very much for this consideration. What attracts my attention in particular is, of course, your proposed innovation. You say, in order to make sure, however, the cultural expertise is applicable on across the specialization, in a wider arena, we need to perhaps identify two specific role of the cultural expert. What you suggest is actually a bifurcation of cultural expertise. And you say cultural experts can be forensic social anthropologists and expert social anthropologists. So these are two distinct roles and two distinct approaches in the production of evidence. But both approaches use a causal model. So in forensic social anthropologists, anthropologists are called upon to independently detect and explain causal processes that link culturally specific idea to real-world human behavior. And in the case of expert social anthropologists, these are called upon to affirm that causal model defined by the terms of given legal process have either been substantiated or not. This is really on the model of physical anthropology, as far as I understand, so that on the two different stages of producing evidence, but also two different approaches, but both refer or use the causal modeling. And as far as I understand, your proposal is not fixed in the sense that there is a certain flexibility in which I think argues also the value of your proposal, because when we look at the reality in our data collection, we obviously have found a lot of examples that perhaps would contradict this modeling with this theoretical model. And if it was considered, if it was taken as a rigid interpretation of this proposal. But this may also be due, I think, to the diversity of academic traditions and political affiliation within anthropology itself as a discipline. For example, whereas in the American and Australian tradition, physical anthropology or biological anthropology are branches of anthropology, it is not so in continental Europe, where anthropology has mostly been linked with the humanities. And so in some countries, also anthropology has developed a closeness with progressivists in the history of the discipline. It has been developed a closeness with progressivist positions, and in some countries instead with rather conservative views. So this political affiliation has also an impact on the way the relationship between law and culture has been perceived and formulated. And so my first question is whether the innovation that you propose may be slightly further articulated to include those countries where anthropology is more linked to the humanities. My second question is linked instead on the impact of the diverse positionality of anthropology over its methods. And I am in particular asking myself if we can indeed give for granted the causal model. What I mean, it is true that the social sciences have used various methods for establishing the spatial temporal connection between cause and effect. I refer in particular to Sloman, who argues that the causal model is universal because irrespectively from culture, society, and geography, as human beings, we connect causes and effect. But we can, when we talk about cultural expertise in court, we are also in a specific interdisciplinarity or cross-disciplinary area, which is the one of law and anthropology. So according to the juridical sciences, causation is the causal relation between the defendant's conduct and the end result. And if we transplant causation in anthropology, the danger is to consider cultural causes as an external agent that causes certain results. And so this is exactly what most of, if not all, anthropologists find abhorrent. So I fear that if we may not perhaps we need to position the causal model clearly, or perhaps it is just just me that, and I was wondering you know, what are your thoughts? I think that Frey, as the anthropologist Frey, in fact, contributed a little bit to this question by saying that culture cannot be seen as an external agent, but only as an internal agent. So still, I am not sure whether this would be enough for avoiding the risk of using culture as an agent of stereotype, essentialization, or even worse, for example, racialization. So this is my second question. My third question is more a quest for a clarification. I think that I didn't follow exactly or always the distinction between forensic investigator and social expert witness. The forensic investigator would be, if I understand properly, fact-finding, but it seems to me that depending on the legal system, forensic investigator eventually do not really deal with facts, but with ideas, the modeling, or the framework of theory. So perhaps I didn't understand properly, or there is a shift that would benefit for some clarification. And this, of course, also connects to the specific expert practice guideline that in some countries state that the country expert duty that now does not concern the establishment of fact, but only whether those facts are consistent with expert knowledge. And in some other countries, specifically those countries where anthropology is more linked with humanity, this distinction is not really relevant. Thank you very much.
Wonderful. These are fantastic questions and very closely interlinked. So I may wind up answering some parts of them, you know, interdependently as I move through, and I might work my way backwards in reverse. So starting with question 3, we talk about this distinction between the investigative function of forensic anthropology versus the responsive function of expert witnessing or of expert knowledge in particular. And I apologize in advance if I contextualize a lot of my answers by the experience of working in the Australian court and administrative system, because of course this is where I've worked my entire career. I have worked a little bit in South America, but not in courts. So, you know, the reason that we feel in Australia that this distinction is important is because many of us do both kinds of work. And we spend a large amount of time explaining to judges and to lawyers and various other people the difference between the two different kinds of work, and why when they're preparing briefs, it's important for them to understand what it is they're asking us to do. And the reason that this takes so much time is that often we find ourselves working with specialist legal representatives, so specialist law firms. We have, for example, an area of law in Australia known as native title, which is a statutory area of law. It's established by the Commonwealth Native Title Act, which provides instruments for Indigenous parties to make claims, what they call bundles of rights claims, either to ownership of land or to, for example, the right to access land without owning it, or to, for example, collect natural resources such as timber and game on land without owning it. And in some instances, they'll combine different elements of these rights provided under this statute. And that particular piece of legislation also requires that the federal government provide funding to establish specialized law firms, the NGOs, non-profit organizations whose exclusive function is to support such land claims under this single piece of legislation. And so when lawyers who work for these law firms brief social anthropologists to provide evidence, they have no real conception of all of the different kinds of work that social anthropologists do. And the particular configuration of the Native Title Act is such that there is tremendous flexibility in how the evidence is prepared and how the argument is made in court, so that the anthropologist plays a very important role, because they are not simply responding to predetermined questions. They are, in fact, as Freckleton says, contributing to the development of the legal strategy. They are going out into the bush, or in some cases in urban environments, interviewing people, sometimes many hundreds of people, and building models of evidence, collecting information of facts, and then in addition, writing these reports and then providing responsive questions to respondent parties under cross-examination in the court. So this was my job for 13 years. At the same time, there are other pieces of legislation in Australia which are much more procedural, where the determination is predefined by the types of evidence and the types of causal model that is assumed by a tribunal or some other legally empowered body. And in those cases where social anthropologists are called to provide evidence, they have no power to establish the facts, simply to answer almost yes or no questions. And so they're very distinct types of work. But most social anthropologists who engage with the law in Australia perform one or another or some combination of these roles. And we feel that it would be to the benefit of the legal representatives that work for Indigenous communities or against Indigenous communities to understand this difference when they brief us. So that is the important part of this distinction that we think has real application here, where, in summary, the forensic investigative function is focused on the establishment of facts in a much more creative and agent-oriented manner, whereas the expert knowledge function is a much more responsive and predetermined sort of function. So that's question or answer 3. Moving back to answer 2, we talk about causal models. This is related, in fact, because, and you hit the nail on the head very clearly there, Livia, I think. In the case of forensic anthropological work, the causal model is often not yet defined. So we have a judge asking, for example, an Indigenous party making a claim to say, well, you explain to me how your culture makes you a distinct people. And then you explain to me how your culture, via your distinct existence as a distinct people, connects you with this particular area of land, such that it might be recognized under law. And so the opportunity to develop a causal model of how such distinct identity and distinct association arises is really up to the community itself, their legal representatives, and then their experts. By contrast, we have other statutory regimes which are generally administered by tribunals, which say, well, we already have a theory of causality. Our theory of causality is such that you have a right to, for example, protect a sacred site. And many people here, I think in Europe, would be familiar with Uluru, Ayers Rock. Everybody recognizes this as sacred. In order for you, says the judge, says the tribunal delegate, to demonstrate that you are the appropriate custodians of this sacred site, you must tick this box and this box and this box, where the boxes are attached to a causal model of association that was established under statute in the 1970s or 1980s or something. And in many cases, that causal model is wrong, you know, but that's what we have to work with, unfortunately. So this is linked to, obviously, answer 3. In that case, you don't need a forensic investigator because the model exists. You really need an expert who's able to answer the questions as accurately and usefully as possible under the circumstances. So that goes to the meaning in this case of cause and effect. The question of whether causality is external or internal is interesting, but my usage of the term is derived from the work of Murray Leaf and Dwight Reed at the University of Texas and University of California, Los Angeles, who are kinship specialists. And their approach is closely aligned to the work of complexity theorists who also work in anthropology. Douglas White, also at UCLA, Michael Hausman, Klaus Hamburger, and others, who describe a process of emergent complexity in the course of humans instantiating the ideas that they believe to give order to their universes. So where we have commonly held ideas such that they give rise to a particular pattern of behavior across a community, we see emerging patterns of behavior. The behavior that then becomes predominant in turn contextualizes the way the ideas themselves are transmitted within the community, whether intergenerationally or laterally from different branches. And we see microcosms of this during the pandemic around this conspiracy thinking around vaccines and so forth, this lateral spread of ideas, which is giving rise to very particular kinds of behavior. So when we talk about causes and effects, it's not so much a question of external or internal in a sort of a universal sense, so much as a system of feedbacks, which then generate from a local level emergent patterns of complexity at a global level. And in a legal setting, if we have appropriate technology and the conditions are sufficient, we have sufficient data, it is possible to demonstrate the lineage of circular causality feeding back in these loops, which of course are very dynamic and always changing. So that's question 2. And then this leads, of course, to the answer to question 1, which is the link between science and humanities, which I think many of us would be familiar with already. And there's 2 answers. You know, the first answer is ideological. So of course we can trace the divergence of natural and social sciences to the Industrial Revolution, because of course natural sciences serve an economic benefit in the generation of profit in increasingly efficient cycles, so that we get larger and larger profit with less and less energy inputs, more and more effective forms of exploitation of labor. The humanities works in the opposite direction. It's always telling us that exploitation is what's occurring and inequality is what's occurring. So historically, we have a divergent trajectory where it's not in the interests of those who make the profit to support a fully scientific realization of humanities, because it would reveal, in fact, the inequality that drives scientifically driven profit making. So we have an inequality in that sense. The other way to answer this is that partly as a consequence of this history, this material history, we have 2 very different forms of organizing language in the humanities and the sciences. So I have there's a pedagogic sociologist, Basil Bernstein, who worked closely with the semiotician Michael Halliday. And they developed a model of the reproduction of knowledge in the academy. Natural scientific language is reproduced, they said, in a hierarchical fashion, where we start off with very specific observations of phenomena. We record these, we measure them, and then we make predictions about the next round of observations that we make. And if the predictions are accurate, then we adopt a model, we formalize it with mathematics, we develop technology for making these predictions more and more accurately and more rapidly. Microscopes to telescopes, for example. And then we're able to generate increasingly general propositions so that we are able to make predictions about biological processes, chemical processes, physical processes, and then we integrate them into more and more general themes of thought using this thing called the scientific method. Meanwhile, in the humanities, we don't have a hierarchical knowledge structure, we have a horizontal knowledge structure, where the predominant means for reproducing knowledge is not through resolution of difference, but rather through the reproduction of difference. We're always competing for better ideas, you know, and then rather than resolving into a higher order system of concepts, we defeat the old idea and we throw it away. we never integrate it. And this is part of why the judicial system is always so confused by humanities evidence, because they're so accustomed to dealing with ballistics experts or geneticists, whereas we're always arguing as humanities people.